Good afternoon, everyone. Today I'm present you competition policy and property rights of John Vickers from Oxford University paper. It's about current competition policy and how it's dealing by the market-powered companies their property and intellectual rights with their rivals. Importance of this paper is first version is written in 1988, but it's still up to date. That is the reason why I chose this topic. It's about keeping rights, rely on regulations, and detecting predatory. Mine is the 10th version, of which is revisioned in May 2009. I will discuss the paper with cases from US and Europe. Price squeezing will be mentioned in the cases, and then we will see the effects on innovations, and one more case of Microsoft, and then finally I'm going to make a conclusion. Before I start, I would like to give you further information about the paper. It is cited in a book named Privatization and Economic Analysis in 1988, which published by MIT Press, and the writer of the paper and book is the same. And also it is used in an article in 2001, Competing Inventors, and the Incentive to Invent by Daniel F. Spalberg in Northern University, USA. And the last thing that I would like to mention, technology adoption and the investment climate firm level evidence for Eastern Europe and Central Asia in 2010, which prepared by the World Bank workers. As you can see, it's the feature of being a global concern, and that's why I like it too. The first case from the US in 2004 called Trico, also the name of the firm. They were blaming Verizon, which Verizon is very well known internet access company from New York, and it is blamed that its marketing behaviors running on discrimination and inadequate. In February 2009, another internet service firm called Linkline was against the Californian company AT&T, very famous telecommunication company in America, because of price squeezing. And they advocated that it must be a violation of US antitrust law. And what is US antitrust law? It's about the fair competition and against of monopolists. It bears to the end of the 19th century, so it must be secured and rooted. Nevertheless, for both cases, all of the 9 Supreme Court justices couldn't find any violation of US antitrust law. You see the Trico and Linkline here didn't have their own infrastructure of network, and that's why they are using of Verizon's and AT&T's. So that's why justices couldn't find any violation of US antitrust law, because in the case that they would like to be monopolist, they don't just even share the infrastructure with the Trico and Linkline. In contrast, in Europe, the Court of First Instance, CFI, in Luxembourg in 2008 upheld a decision by the European Commission that Deutsche Telekom had abused a dominant position by operating a price squeeze against rivals. For the national regulatory, prices were not unfairly. Even so, the decision of CFI was opposite of national regulation. So that's why they had to step back. Another firm called Wanadu, which is a part of France Telecom, had engaged unlawful predatory pricing to eliminate rivals in the markets for high-speed internet access. And this is confirmed by the European Court of Justice in April 2009, and they had to step back too. So, I always mentioned the price squeezing for both cases in US and Europe. What is the price squeezing? Basically, it is used by vertically integrated firms. Because of being vertically integrated, they have less cost values and much more profit than the other firms which cannot achieve being a vertical integrated. With this way, they can reduce purchase price and eliminate the other firms in low-end market. The other way is as an incumbent firm which provides products and services to the low-end market firms. They sell overcharge in the market and won't let other firms enter in the market, and this must be illegal. If in the case that they detected, they have to pay very much penalties. And what is this all about property rights? In the simplest term, I can explain it: if someone eats your lunch, then you can't eat it. Well, it's not valid for ideas. If I use your ideas, then you can still continue to use your ideas too. But at some point, they are connected to each other, in particular for companies and their company lives. As a company, if you are not exist, then your ideas neither, unfortunately. And this causes three effects on innovation. First of all, the front-loading effect. It's stressful because there's always a potential of other entrants in the market while you have to keep your company's position in the market. So you have to make innovation to survive by the incumbents secure. You are protection of incumbents, but it's a little bit risky because you are protected by the incumbent as long as it keeps value of incumbency. If you're not supported, you cannot survive in the market. Second is neck and neck effect. It's efficient as long as firms support themselves together. So there will be more chances to make innovation instead of competition. If one firm reduces, then another firm reduces too on the prices. Third and last effect is follow-on innovation. Means in the case of a firm holds a powerful position about intellectual property rights that hard to pay the price or use it, then you have to try another way to make your own innovations by yourselves. The last thing before conclusion is about cases of Microsoft in 2007. CFI gave the judgment to rely on European Commission's decision in 2004. The firm is claimed that refusing to cooperation with rivals. But the judge was opposite of it because it was protecting by the intellectual property rights. In the US, there was another claim that unlawfully maintained its operating system, but also this is again rejected by the Court of Appeals because of the protection of intellectual property rights. The case is closed unclearly. As you see, the US and Europe both rejected the cases, but they had accepted different regulations and different decisions in the above cases. To sum up, I would like to underline the word of regulation because it is the essential title that we have to be careful on when we discuss these kind of issues. Unfortunately, there is no one specific answer relying on difference between US court-based system and Europe primarily administrative system. Even in some cases that I mentioned the above slides show similarity or differentiates. From my perspective, I strongly believe that if you have an original idea for the market, then you have to take under protection. Otherwise, it could be used by privately, and this is more injustice. But of course, you have to be fair on pricing when you sell or bring into service. And thank you for your attention.
Okay.